And as Kimberly said, I am the education director at Texas American Title. So I go around and teach classes out of our TATCO branches or to independent broker offices such as this. There were some TAR changes on documents for January 1, 2014, and this is our package. So we're going to kind of go over them. It's real simple to see exactly what the changes were. As we go through, you'll see the changes that affect the documents are redlined. So you're not going to be searching. I'm not going to be telling you, third sentence down halfway to the right. So if we'll go ahead and get started, the very first document is going to be your residential real estate listing agreement, exclusive right to sell. And the very first change is going to be on page 3. And you'll see right there where it says reimbursable fees, they have added other fees and or. Okay? So travel trip fees, any of kind of those other things are also going to now be included. And then in paragraph E, under protection period, paragraph 1, sell means to transfer any fee simple properties, which we understand fee simple or leasehold is the way you take title on a property. Yes, sir.
Can you back up to that on other fees and or?
Uh-huh.
Wasn't there some debate about people charging for this, that, and whatnot that really wasn't applicable? Is that where they can now put it in?
Yes. So it's opened up the door for you to be able to get a little bit more in there. So when we get down to like the residential leases and stuff like that, you'll see now landlords or property managers are allowed to write down what they call trips or transfer trips where they're having to go out to the party or out to the property where they used to not be able to claim that mileage. Now they can. That's right, and that's also addressed in other fees in one of the documents. Yes. Did that help you, sir?
Okay.
Okay. All right. So then we'll go ahead and go to page 9, and the fair housing paragraph has been changed. So now it reads, in accordance with fair housing laws and National Association of Realtors Code of Ethics, broker services must provide the property, must be provided, and the property must be shown and made available to all persons without regard to race, color, religion, national origin, sex, disability, familial status, sexual orientation, or gender identity. Local ordinances may provide for additional protected classes, for example, creed, status as a student, marital status, or age. So absolutely no discrimination.
What has changed in that statement?
Sexual identity.
Okay.
Are there any questions? No? Okay, then on the last page, you know that back in 2012, the 1-to-4 family contract was it was added to add a broker or a supervisor broker signature to the back page. You're going to see that it's mainstream, it's lining now, where a lot of these documents now they're adding the broker signature to the back page, and that's what you're going to see here is on page 11 that the broker signature has been added.
Is that going to be required?
Yes.
Is that what you're saying?
Yes, it is now on the 2014 TREC form.
Where do you need the broker signature?
Authorization, just like on a contract.
So we can't submit anything.
Of course you can, but at some point your broker needs, and when it goes into a file, it should have a signature.
Really?
Mm-hmm.
Is that in effect right now?
As of January 1st of 2014.
But it gives you 2 check boxes, so you can check box either the
Brokers or brokers,
you can check box the associate.
that's right. That's absolutely right.
But not both.
No. One or the other.
Right. Okay.
Oh, okay.
And so where the associates. Yeah. Right.
I'm sorry, sometimes in the title world we use the terms broker, sometimes crosses over into a different way of how you may use the word broker. So I apologize if that misled you. Seemed everybody was on their edge of their seat there for a second. Is that clarified now?
Yes.
Okay. Okay, so now we're going to go into the same thing, but it's your exclusive right to lease. A lot of these documents are going to be where the leases are coming into play. Lease properties, well, you'll see. So the first change is going to be actually quite a distance back. Yeah. Page 4. You're going to notice that the word seller has been taken out and is now referred to as landlord. So there's no possibility of anybody thinking that this is a purchase, that this is in fact a lease. Okay? Yeah, I mean, some of these changes, when you think about it, it's like, okay, really? Wow. Okay, and then if you'll go to page 10, and again, your fair housing laws have been updated in this to refer to, in accordance with the fair housing laws and the National Association of Realtors Brokers Code of Ethics, property must be shown and made available to all persons without regard to race, color, religion, national origin, sex, disability, familial status, sexual orientation, or gender identity has been added to that paragraph there. The property code requires that property be equipped with certain types of locks and security devices, including, with some exceptions, 1, window latches on windows, 2, a key doorknob lock or keyed deadbolt lock to each exterior door, 3, a sliding door pin lock on each exterior sliding door of the dwelling, 4, a sliding door handle latch or a sliding door security bar on each exterior sliding glass door of the dwelling, and 5, a keyless bolting device and a door viewer in which the exterior door of the on each exterior door of the property. The property code also requires smoke detectors as crossed out alarms. Not all detectors make a whistle, alarms will.
So a glass front door
Glass front door.
would suffice. You don't need little people.
That's right.
Right. But what about an exterior back door or side door? Does it need little peepholes on it?
Or the ability to see whoever is at the door. So sometimes, you know, these doors have like the side panels. That would be sufficient. But there has to be the ability for somebody to see whoever is at the door.
Back or side?
Back, any exterior door.
What about an exterior door going out from the garage, say to the side yard or something?
That's probably debatable, but that could be said that it's an exterior door. It would be dependent, you know, is it a detached garage or is it an attached garage? Is there? I mean, there was a lot of things there where we've gotten in discussions about that. If it's an attached garage, the answer to your question, I would assume, would be yes. Because then there's a direct entrance into the property itself, the dwelling.
And it doesn't mention garage doors here.
No, it doesn't. But the garage is considered to be part of the dwelling. So it says any exterior door of the dwelling.
So is that left up to interpretation, or is that like a top check with the broker?
Well, you want to verify. Always, if you have any questions, go to the property code, and that will be much more explicit for you. Okay.
If you have a detached garage, the door going from the garage to the side of the house, is that a iffy?
I would say that it could be argued, but because there's no direct entrance into the living dwelling from the garage at that point, it could be an arguable point, but you don't want to put yourself into a position where it can be argued. And again, check the property code. I mean, the property code is going to give you more in-depth than just a disclosure. Okay? You're welcome. Any other questions?
Where do we get the property since you're referring to it?
Property code's available for you,
You can Google it.
yeah, online.
I just think that it just wouldn't make sense to have people in a garage door that's detached.
Well, remember that when changes get made to documents, it's because there's been lawsuits. So what's happening here is people are the documents, it's happened enough, or it's been brought to the attention of somebody enough to warrant the thought that it should be updated.
It says each exterior door of the dwelling. So the dwelling would be where they live, not the garage, wouldn't it?
But if the garage is attached.
If the garage is attached, yes, but if it's not.
Right, but remember that as a realtor, it's not your job to interpret.
That's right.
Okay? Remember that you don't want to interpret, you don't want to go in full length of discussion of the documents, because then you are going on board around counsel. So what it would be your best thing to do is to go to the property code and get it for verbiage.
Can you tell us what the difference between detectors and alarms is, as far as what they're referring to?
All detectors do not make a loud noise. All alarms will.
Do they want the detectors to make noise?
Well, the word detector does not necessarily make you think that it's going to make like a loud noise. Like when your battery goes out on your fire alarm and it starts beeping at you, not all detectors make noise. All alarms will make noise. Okay? So, again, it's the interpretation of the word. Okay? Okay, so on the seller's disclosure, were there any questions on that? Exclusive right to lease? No? Okay. Seller's disclosure. On page 2, towards the bottom under section 3, the additions are located in a historic district, historic property designation. Previous fires has been moved to the right-hand side.
Why, if they change the verbiage to landlord, like just reading section 3, are you seller aware of the following conditions?
This is the seller's disclosure.
Oh, that's the seller. Okay, sorry.
That's okay.
Do you still need a seller's disclosure if you have a lease more than 1 year?
I don't know the answer to that question. Okay, so page 3 of 5. Down at the bottom, any rainwater harvesting system located on the property that is larger than 500 gallons and that uses a public water supply as an auxiliary water source. And then also what has been added to the seller's disclosure is the property is located in a propane gas system service area owned by Propane Distribution Systems retailer. So the one thing that you want to make sure is if you have a seller that has a propane gas tank, A, do they own it or do they lease it? Okay, not everybody buys them. So that's one thing you want to make sure it's clarified in your seller's disclosure.
And this is specifically referring to a distribution system where the propane tank is not located on the property. Isn't that the case?
Correct.
Okay.
Yeah.
Okay, now, you mentioned one thing, Frank mentioned something else. Frank was talking about a group of houses that belong, and there's one central propane
Yes,
tank. That's
exactly,
it.
exactly.
He's talking about a physical tank on the property, may be owned by them, may not be.
It could be a lease. It could be a leased propane tank. But whether it's a group of houses or an individual, this is probably addressing an individual property. So what's become popular is for a lot of homes or people to heat their pools with these propane tanks because it's cheaper than natural gas.
The question is how are we supposed to answer this?
Is there a propane tank on the property?
It doesn't say that.
The property is located in a propane gas system service area owned by a propane distribution system. Is that propane tank owned by the distribution system?
Or is the tank itself leased?
Well,
Or
what what he was referring to makes more sense to what a distribution system is several people on one tank. That's a distribution system in my mindset.
Okay.
But I understand what you're saying because that would be an issue, but that's the only comment I'd say is that is the propane tank owned or leased?
That's exactly right.
Okay, that's not what this says.
Well,
Please, do we still check it?
well, no. If it's then is it this? If it's not leased, then it's not going to come with the sale of the property unless your buyer wants to enter into another agreement. That agreement is between the propane company and your current seller, right?
Okay,
So is it the seller's intent to take away that propane tank?
would that tank be considered personal property? Is it attached or unattached?
Well, I would consider it be attached, but if it's attached and leased,
Because there might be a fee associated with that.
right?
But what Frank is talking about, I mean, if it's a community tank or what, a system owned by several people. or-
Yeah, where the gas is distributed from a central distribution point piped to the individual
So
homes.
basically, all you'd say is yes,
Yeah,
Yeah, and in that situation, that's how I would interpret that.
that's
yeah,
how I
Just
would
check.
too.
yeah. That's why I was trying to just put
Right,
two different worlds.
right.
If in doubt, check and spring.
Yeah.
Yeah,
Back to the code.
that's right. Always check with your broker. Page 4. Section 9, have you as seller ever filed a claim for property or for damage to the property with any insurance provider, yes or no? Mm-hmm. That's right. So, you know, if anybody, a lot of your sellers, if they were in the house prior to Ike, that's something that you want to make sure they answer correctly.
So then the next paragraph just refers to if they did file a claim, then
Were they paid?
were they paid and did they use those funds?
That's right, because, you know, like I got a new roof out of Ike, and when I took that check, I signed a piece of paper stating it was my intention that a new roof would be put on my house. So, and yeah, do they see it as a way to take $10,000 and put it in the stock market and play with it, and do a patchwork with roofing? So, okay. The next document that has a change is the residential lease.
Are we skipping over the addendum for sale of other property?
There's not a change on it.
There's not a change.
The residential lease gets longer and longer.
And more detailed. Okay, so paragraph 4 under automatic renewal and notice of termination. This lease automatically renews on a month-to-month basis unless landlord or tenant provides the other party written notice of termination as provided in paragraph 4A. Oral notice of termination is not sufficient under any circumstances. Time is of the essence for providing notice of termination. Strict compliance with dates by which notice must be provided and is required. The date on which the rent is due does not apply to the requirement for providing written notice of termination. If a box is not checked under paragraph 4A, paragraph 4A1 will apply. If a box is not checked under paragraph 4B, paragraph 4B1 will apply. So A, this lease automatically renews on a month-to-month basis unless landlord or tenant provides 30 days before the expiration date. Okay? Pretty clear. And page 2. If landlord or tenant fails to provide the other party timely written notice of termination as required by paragraph 4A, the lease automatically renews on a month-to-month basis. The landlord or tenant must then provide a subsequent written notice of termination as required by paragraph 4B. All right? Paragraph C was amended to read as what we just read. D, methods of payment. Landlord may not charge a reasonable fee to process or accept any payment by, select one or more of the following if the landlord indicates a reasonable fee may be charged: cashier's check, electronic payment, money order, personal check, or other means acceptable to the landlord. So if the bank is processing fees these days, which banks are processing fees for everything these days, now that landlord can recoup the fee that he is charged for processing that payment.
When does he recoup it? I mean, at the end of the lease, or does he
It just adds an additional cost. Notification. Security deposit on page 4. Any additional deposits tenant pays to the landlord other than the security deposit will become part of the security deposit. And this is what we were talking about before. If you'll go on to page 6, please, where it says trip charges.
Okay, I'm sorry, you may have said something here. Any additional deposits tenant pays, how would that impact a non-refundable pet deposit? Would that have to go into a security account?
That's probably going to be negotiated between all of them, or what it is. Any monies that are given to property manager or owner, depending on who's doing it, at that point become part of the security deposit. Whether it's non-refundable or not, that's something that needs to be addressed at the time that the lease is executed.
That would be covered under the
Pet deposit, that's right.
You mean the entire year annual lease?
Yeah, I have to, yeah. What if they wanted to pay the entire lease up front? Would that be considered, I mean, based on that, that would be considered security?
No, No, a security deposit would be an additional monies over and above that. A security deposit would be money that he probably would require a separate check for. So security deposits are what, typically 2 times the monthly rent? One time? So if your monthly rent is $2,000, he's going to take a check for $2,000, and then he's going to take a check for $24,000.
exactly what it says, security.
That's right. That's right.
You know,
And then page 6, please. Trip charges, paragraph 14C. If landlord or landlord's agents have made prior arrangements with tenant to access the property and are denied or are not able to access the property because of tenant's failure to make the property accessible, including but not limited to any occupant, guest, or invitee of the tenant, pet, security device prohibiting access to any area of the property. So if you know that your landlord's going to be coming by and you've got a big dog, put your dog in its crate. If mom's visiting, make sure mom lets the landlord in. And if you've put a different deadbolt device on your door than what the landlord had there for you, don't lock your deadbolt that day. Okay? Yes, ma'am?
Going back to 10A, sometimes landlord would like a double deposit if the tenant doesn't have like all that credit. So that would go in there?
Yes.
Okay.
what was your question?
If there's a double
deposit.
due to credit limitations, would that go into that security deposit account? Answer, yes.
Another question about a deadbolt lock. You don't have to make a copy of the key and give it to the landlord?
I was just using that as a suggested example. I would imagine that yes, you do. But should you have just changed it on Saturday and something happened? Yeah, I was just using that as an example. Yeah. Yeah. Property maintenance. I'm sorry, excuse me, page 8. Paragraph 17, number A9. Pay any periodic preventative and additional extermination costs desired by the tenant, including treatment for bed bugs unless otherwise required by law. Yeah. Paragraph B, yard maintenance. Maintaining the yard means you will perform activities such as, but not limited to, mowing, fertilizing, trimming the yard, controlling pests and weeds. And weeds. Okay. The next page, which is page 9, paragraph E, failure to maintain. If a tenant fails to comply with paragraph 17 under any pool spa maintenance addendum, landlord may, in addition to exercising landlord's remedies under paragraph 27, perform whatever action tenant is obligated to perform, and tenant may immediately reimburse landlord the reasonable expenses that the landlord incurs, plus any administrative fees assessed by the landlord's agents or any other entity as provided by law. F, smoking. Smoking by the tenant, tenant's guests, family, or occupants is permitted, not permitted on the property, including but not limited to the garage, outdoor areas of the property. Yeah, they're getting serious about that one too. That's right. It's the landlord's investment, not the renters. 18, repairs, repair requests, paragraph A, down towards the bottom. Health or safety of any ordinary tenant. Tenant may call landlord or, if applicable, the property manager at. So now the property information is right there, and it's designed to tell the landlord or the tenant exactly who they're calling. And then page 10, item D, payment of repair costs has been updated to read, except as otherwise specified in this lease, landlord will pay to repair or remedy conditions in the property in need of repair if tenant complies with the procedures for requesting repairs as described in this paragraph 18. This includes, but is not limited to, repairs to the following items not caused by tenant or tenant's negligence. Okay. Security devices and other exterior door locks. This paragraph reads exactly what we were talking about in the lease application, or the exclusive right to lease. So if you want me to go over it again, I will, but it addresses just the same thing as the window latches, the doorknobs, deadbolts, eye peep holes, da-da-da-da-da-da. Okay? But this time it's in the lease. All right?
Is there a certain 7 days if it doesn't, if the property doesn't have these items listed? Then the landlord has 7 days.
7 days after tenant moves in.
To satisfy that requirement.
That's right.
Paragraph B, underneath that.
Sure.
Is all notice or request by tenant for rekeying, et cetera, must be in writing. I presume that would be a second rekeying because they're not requiring the tenant to make the initial.
I would assume the same thing. Yes. Okay, so the next change actually is at the top of page 13, but it kind of comes in with early termination starting at the bottom with paragraph 28 and the bottom of page 12. So early termination, not entitled to early termination due to voluntary or involuntary job or school transfer, changes of marital status, loss of employment, loss of co-tenants, changes in health, purchase of property, or death. So don't purposely die. That's right. Because it's not going to work. That's right. And then continuing in paragraph A, item 3, sexual offenses or stalking. Okay, so certain sexual offenses or stalking, if the tenant provides landlord with documentation required by 92.0161 property tax code, or property code, excuse me. So stalking has been added into sexual offenses. Yes? Page 14, agreement and application, deposit and hold has been deleted. And then moving on to page 15, G, this is going to be, as always sparks a little conversation. If an active realtor, member of the Texas Association of Realtors, does not negotiate this lease as a party for one of the parties, with or without the assistance of an active member of the State Board of Texas, this lead is voidable by the tenant at any time. So a realtor must always be involved with the execution of this document for it to be an upholdable document. Whether you have an attorney or a landlord or a property manager or anybody, a realtor must be involved.
On the lease.
Using this document, which is the lease document. Okay?
So someone can't, if it owns a piece of property, they're not a realtor, and they can't just pull this form and just use it themselves, or it's not going to be, it can't be upheld.
If your tenant finds out that that's not a legal document unless a realtor was used, you have no recourse.
Does that mean on both sides or one side?
Both sides. Well, it's really the landlord that you're concerned about. I mean, not the landlord, the tenant.
Either.
But it's going to be either.
Yeah, because we represent somebody and the landlord may not be an agent.
It says in here, as a party, the realtor is a party to the lease, or on behalf or for one of the parties. So as long as there's a realtor involved, it's valid.
Right.
But a landlord should have the right to.
That's going to be page 15, top of the page, under G for copyright.
But a landlord could have their own paperwork without having this contract.
That's right. But if this contract is used and a realtor is not involved, it's not an enforceable contract.
Well, I guess it wouldn't, but Trek has a lot of these forms online the public can use.
This is tar.
Yeah, but is it?
No. I had to obtain these from a friend of mine who is a realtor, because even though I am a member of HAR, I am not a realtor member of HAR, so therefore I had no way of being able to get into these forms. Okay? So you can't use TAR or HAR forms as Joe or Susie Smith. That means that they know a Texas realtor if that document is being involved.
They may know somebody to get the form, but they have to have an agent sign off on it.
That's absolutely right. Right. Right.
So you're in big trouble. You can't provide this form to an owner because he has his property for lease by owner, and he comes to you and says, okay, I need one of those lease forms.
You should not be providing any realtor stamped forms to anybody for any purpose. That's right. That goes against your ethics. Okay? Okay, down towards the bottom of the page, H. Landlord's insurance does not cover tenant from loss of property, personal property. Landlord highly recommends that each tenant obtain liability insurance for casualties such as fire, flood, water damage, and theft. Not requires, highly recommends. Right.
So recommending it does not mean that they have to care.
No, but also your landlord, if you have investment property, your insurance on the property should be inclusive of renter's insurance, people living in the property as a renter. If the house burns down and you don't have that policy, the insurance policy may or may not pay for damage.
When you say damage, are you talking about structure or contents?
Structure.
Structure, yes. Because the landlord should be insuring the structure, the tenant should be insuring contents, and with this change, also liability.
That's absolutely right. Yeah, it's like renter's insurance. The renter should, or the tenant should be insuring their interior contents as well as liability.
So if somebody falls in your house, inside the house,
Well, if they're allowed to smoke in the house and they fall asleep with their cigarette on the sofa. Okay, so that could be a problem. It's a real problem if they were not supposed to smoke in the house, but okay. Whole nother deal. Right. Okay, so page 16. And then down at the bottom, well, residential lease concerning, and then it's going to have an address. Down at the bottom, it's added for landlord's use. Landlord must provide at least one copy of the lease to at least one tenant no later than 3 business days after the date the lease is signed by each party to the lease. Additionally, if more than one tenant is a party to the lease no later than 3 business days after the date the landlord receives written request for a copy of the lease from a tenant who has not already